Hello everyone, I am Dharshan Govinth, an intern at ubAdvocate. Today I will be discussing about a joint Hindu family and Coparcenary. First of all, we shall discuss about what is a joint Hindu family. A joint Hindu family is an inevitable and a fundamental concept of the Hindu family law. Generally, there are two main schools of the Hindu family law, which are Mitaksara and Dayabhika school of law. And this concept of joint Hindu family is same in both the schools of law. A joint Hindu family originates from a common male ancestor and is generally composed of all male linear descendants, their mothers, wives, widows, and unmarried daughters. Widows returning to their father's home also form a part of a joint Hindu family. Through the case of Guru Narayan Das versus Guru Taharidas, even an illegitimate son of a male linear descendant form a part of a joint Hindu family. A joint Hindu family is represented by Karta, who is the senior most male member of a family, and the females were never given the recognition of Karta anywhere. The presence of a common ancestor is necessary for the formation of a joint Hindu family, but it is not needed for its continuance. This is because a joint Hindu family continues in existence even after the death of a founder, that is the common male ancestor, unless the existence is disrupted by way of partition in the family. Generally, a membership in the joint Hindu family is acquired by three ways. First, by birth, second, by marriage, and third, by adoption. A membership in the joint Hindu family is ceased when any of the following four events happen: when there is a conversion to another religion, or when there is a marriage to a non-Hindu, or when a person is given in adoption to a third party, or when there is a marriage of a daughter. In the second part, we will discuss about what is a coparcenary. A coparcenary is a narrow part of the joint Hindu family, and it is considered to be a status which gives birthright in the joint Hindu family property. A coparcenary mainly consists of all male linear descendants up to three generations, that is, the common male ancestor and his son, grandson, and grandson's son. And the female members of a family are not considered as coparceners, unlike in the joint Hindu family, where the members even constitute the female members. Members of a coparcenary are only related by blood or by valid adoption, unlike the joint Hindu family, where the members are even related by marriage or by any other agreement. The presence of a senior most male member is compulsory to start a coparcenary. The presence of at least two male members is necessary to constitute or even to continue coparcenary. The coparcenary comes to an end by means of partition, or by the death of all male members of a family, or by the death of the sole surviving coparcenary. Thus comes the rule of survivorship. This rule of survivorship is only applicable in the Mitaksara school of law and not in the Dayabhika school of law. And the Dayabhika school of law even does not recognize the concept of coparcenary. Following this, it is also important to discuss about the status of women as coparcenary. As per the Hindu Succession Act of 1956, no female member could be a coparcenary. However, this situation was changed post the 2005 amendment to the Hindu Succession Act of 1956, which was seen as a remarkable step towards the eradication of gender inequality. This amendment also added Section 6 Clause 1 of the Hindu Succession Act, which provided the right to daughters whether they were married or unmarried to be a coparcenary, and it also provided the right by birth to the joint Hindu family property. But still, there is a question which was prevailing around about whether it would apply only to daughters born after September 9, 2005, when this particular amendment came into action, or whether if they were born before that date, it would be limited to those whose father was also alive on that particular day. Even many courts were of the view that only a living coparcenary's daughter would get the benefit of this new law. The Supreme Court itself, in the case of Prakash versus Pulavati, supported this statement. However, in the year 2018, in the case of Vinita Sharma versus Rakesh Sharma, a three-judge bench affirmed the rights of daughters to be a coparcenary. Here the court had upheld the stand that the coparcenary status of daughters is created by birth and it is not dependent on whether the father was alive or not on the particular date when this amendment to the Hindu Succession Act came into force. And thank you so much for watching this video.